So we're very hard pushed to find any actual rules or regulations that set out any proper procedure for petitioning. In the part of proceedings which clearly exists and is part of petitioning proceedings through usage of the jurisdiction of Parliament for the sections and areas of proceedings before it's handed into Parliament, right? Now we're told about the form and manner of petitions, but that's not necessarily advertisements which promote them, right? And therefore you can actually look at the pamphlets from the 1600s, 1700s and 1800s, the actual pamphlets and promotional material itself, right? And I've actually got some pamphlets for private bills. The rules for private bills, it says here, right? This is what it says. In 1685, the House of Commons, during the reign of James II, operated under established procedures focused on controlling legislation and managing business, including the requirement that private bills originate from petitions. So private bills originated from petitions, while specific 1685 only standing orders are often catalogued alongside later revised rules. So that is these ones. These are the standing orders 1685 to 1822, but they're not just the 1885 ones by themselves. They don't actually have any particular rule for public petitions, only for private bills. But you've got things like petitions on religious matters and for divorce were dealt with by Parliament. Now it says that the 1685 Parliament context, the 1685 Parliament, heavily Tory, was initially obedient but ultimately challenged James II's use of prerogative to exempt Catholics from the Test Act. Legislative procedures. Private bills had to originate via petitions, right? So even private bills are originating from petitions, from interested parties which were reviewed by the committee. The House maintained its role in initiating supply bills, taxation. Evolution. Standing orders in this period were often temporary, established by motion, or derived from long-standing unwritten custom, rather than a formal published rule book. So that's before 1685. And then we've got 1685 to 1822, right? While some orders are compiled from this era, they represent the early evolution of procedure rather than modern comprehensive standing orders, right? So these are the standing orders 1685 to 1822, okay? Now, this is before Erskine May did his parliamentary practice books, and the first one was 1844, which is there's a lot less in it than this, and it has got a section on public petitions, but it doesn't talk about canvassing or publicising them. There aren't any special rules which govern the advertising and publicising of them, but we know that it exists. Now, in the back of this official Standing Orders book, 1685 to 1822, it's actually promoting John Hatzell's books, right, and precedents of proceedings in the House of Commons. So instead of Erskine May's parliamentary practice, it's actually referring you to the books of John Hatzell, who actually worked in Parliament, for any more information on official proceedings, right? And this is actually from the John Hatzel's books, which I've got, right, but you'll have to take my word for it. It does say something about publication. And these are the words that it says. I'll read them out to you, right? Whoever will give themselves the trouble to read the entry of this proceeding in the journal of the 14th of February 1580, from whence I have given the foregoing extracts, will find it difficult from the variety of offences of different natures charged against Mr. Hall to deduce any precise idea of privilege. Privilege, as understood by that House of Commons with respect to the printing or publishing the debates or proceedings of the House, provided that such publication was not made in a false and infamous libel, injuriously reflecting on the character of members, impeaching the rights and authority of Parliament. That doesn't mean that you cannot accuse the House or members of anything. That's only false, right? So the whole point of petitioning Parliament is that you can do impeachments. You can do a petition asking for an impeachment, and you can do a petition accusing, because in the rules, right, in the rules of Parliament, this isn't the manuals of procedure from 1987, but they've all got the same rules in. Once we get going from these, once we start getting public petitions in this later on, which I'll get to in a second, right? Petitions contain allegations. If you didn't have allegations, you couldn't have calling for impeachments or reflecting on the character of members. That's only if it's false, right? That's only if you're lying or you made up the accusations reflecting on members. If they actually are substantial and true, you've got the legal right to petition Parliament about them, which is why we now have Daniel Greenberg at the moment, the Parliamentary Commissioner for Standards, right? And the Parliamentary and Health Service Ombudsman for government departments. But you're meant to petition, because Parliament can't be judged in the courts, only in Parliament. So anything that Parliament's done wrong, you've got to do it by petition, but as long as it's not false, right? So you can have impeachments or complaints, but currently they're not wanting to do them. But this is talking about publication of the debates or proceedings. Look, public bills is proceedings before, during and after, which the publication in the newspapers is part of the proceedings, which is why it's protected, right? So the law and privilege of Parliament is not set in common law like judges are normally meant to deal with. It's established through tradition and through the standing orders, right? But here, we're definitely got talking about publication being used in connection with the publishing of proceedings. But this is like, you've got preliminary proceedings. It's like in court, any stage of proceedings. So you've got before proceedings, during proceedings, and after proceedings, just like any court, right? So this refers you to the John Hatzel book, and this is all he's got to say about publication. Now, following this, I've got some more. I've got to show you. We've got this is the 1863 standing orders. We've got the 1880 standing orders and the 1905 standing orders. They're all extremely similar with only slight modifications, right? None of them have, for public petitions are in there, right? Public petitions are in standing orders. Public petitions are through and under standing orders, right? But for the publication and publicity of them, there is no there's no regulations around them. They're not regulated to strict rules like public. The private bills are subject to specific rules to follow in the publication of them, right? So now there is an act of law, right? Petitioning really originates historically before the conquest, but we've got the 1368 observation of due process of law, which sets that the commonality can petition the king. The commonality can come together to petition the king. That's the whole community, right? But before the 1688 Bill of Rights, right to petition, we do have this Tumultuous Petitioning Act 1661. So this is an actual act of law itself about petitioning. And it's actually an act of law about petitioning either of Houses of Parliament or the King, right? So we're on subject now. This is on topic for parliamentary practice, right? This is on topic for the law, privileges, proceedings and usage of Parliament, because we've got an actual act of law here that is on the subject of petitioning either Houses of Parliament or the King. And it restricted how many people could sign petitions with or without consent from a court. But this is now repealed. But we're asking the question, have we got any evidence to know anything that going around and collecting signatures in public or advertising is anything at all to do with petitioning officially? Because, you know, some people are trying to say that, you know, the privileges are only once you hand petitions into your MP and inside the House, not going about outside. Yet private bills proves that publishing it in the newspapers and publicising it is part of standing orders and is under and through standing orders. Now this sentence here in the Tumultuous Petitioning Act 1661, which is on the government website, I got them to put it on there. I asked them to put this on the website for record because it's one of the statutes, even though it's repealed for educational and research purposes like this, what we're using it for now, right? So this is about, it says, solicit, labour or procure the getting of hands or other consent of any persons above the number of 20 or more to any petition, right? So this is exactly what we're talking about doing before we hand them in, right? So this is actually covering this. This is saying that this is part of doing petitions. This confirms that this is part of petitioning in law under the Tumultuous Petitioning Act. The first word here, solicit. So when you're soliciting a petition, you are trying to get people interested in it or making people aware of it, right? And transacting in it. So this is like, I mean, you know, if you look in the dictionary on solicit, what is it to solicit? You're making representations. So this is like what publishing and making things available is, like under the definition of publish, right? Solicit, labour, that means like do anything or do any work towards or make any action or act towards, right? To procuring the getting of hands or other consent. So that's getting people to support it, agree to it, join to it. So that the solicit word in here, to solicit a petition to persons, this is in public, is part of petitioning either Houses of Parliament or the King. It's an acknowledged proceeding here. It's acknowledged as a part of petitioning, to solicit it to the public, right? To solicit and procure people signing it or other consents, right? So the Tumultuous Petitioning Act 1661 proves that. Now, as well as these standing orders and the Erskine May parliamentary practice, We also get these manuals of procedure in the public business, right, from around 1904. This is 1924 one, but this started around 1904, 1908, and the final one was 1987. These have also got procedures for claiming privilege directly to the House of Commons by petition, presenting it in the House, and it took precedence over all other business in the House. It was quite important, right? That would have probably been if the Parliamentary Papers Act didn't work, if the court didn't accept your claim, when you used it properly under Section 2, like I'm suggesting now, you could probably complain to Parliament about it and get them in. There are lots, in John Hatzel's books, there are lots of instances of contempt of judges, sheriffs, bailiffs being called into Parliament, right? Now, these manuals, right, are like they're like a mini version, a condensed version of the parliamentary practice and the standing orders, right? They effectively are mini handheld versions of the standing orders, just so it's like a little quick manual to look through procedure, right? That's what they are. But for public petitions, there's still no set rules or regulations around the promotion and advertising of petitions in public. This part of it, other than when there was this act in force, right? And in modern law, we definitely have the Control of Advertisements 2007, says that you can use any act of law. This would have been one of the acts of law which you would use in it. Now, I want to draw your attention to this, right? What even is this? This is from 1837, okay, June the 8th, and it's a debate in Hansard on the Journal about the publication of papers. And this is page 1269 and 1270. So the date is the 8th of June, and the matter is privilege, the publication of papers. And this is from the 1837, I think, Journal or Hansard. And if you look here at the bottom of the page, it says this. And I printed this in large for you, so this is what it says there. You'll have to take my word for it, right? Parliamentary Journals, 1837, breach of privilege, April 17th. This is when it was debated, right? I don't know if it's the Journal or Hansard, I forgot, but I think it might be in both, right? You'll have to check up on that. But this is the exact wording from it. And this is talking about an example case. This is a case study, right? We're on case study now. Why was he debarred from redress? Because in his case, as in others, the privilege of Parliament protected the presentation of the petition, the printing of that petition, of all the documents connected with it, of the accusatory evidence given at the bar, and it would have been thought preposterous if Mr. Kendrick, held in public trust and charged with the abuse of it, had sought redress from the Court of King's Bench against such done or authorised by the House of Commons in whatever manner they might acquire publicity. So you're authorised through standing orders to do public petitions, and you're directed to do them, right? And collect signatures. But there are no regulations for those proceedings, as in there are no strict rules for it. There are no strict or specific rules like with public bills, which is kind of like election law. There are strict rules, right? So all documents connected with the petition and accusatory evidence are protected by the privilege of Parliament, right? And this is what we're getting into with the Parliamentary Papers Act, but they don't necessarily have to be in paper form, though, or all evidence, right? In the case. But this includes the actual petition itself and the advertisements and anything connected with it, right? And I've got these, let's come forward to around 1973 now, which is around just before they finished doing these manuals of procedure in the public business, right? This is what the 1973 Petitions Committee report. These are some extracts I've got, and I've done it in dark, bold colour, a couple of sentences which are relevant, right? So here, the committee are aware that it would leave no further merit to petition in Parliament other than the publicity generated by the collection of the signatures. So here, they're admitting that when people go about collecting signatures for public petitions, it generates publicity and an interest in it. And they're saying that that's a benefit. They're saying that at the time they had a very weak and feeble petitions committee who were only meeting for about a minute 4 times a year, and they were not very efficient or effective. In fact, in 1973, after that committee report, they scrapped the petitions committee, and all petitions presented to the House were given directly to ministers of the Crown until they reintroduced the petitions committee in 2010, right, properly, with the e-petition service. So here it's saying the words, this is actually by the report of 1973-74 Committee of Parliament for Public Petitions. They're acknowledging publicity generated by the collection of signatures. So this is people putting it in newspapers or handing leaflets out or having copies of it that you can sign in shops or at the council, or maybe sometimes even in courts. They had them in the reception and things like that, right? So that they're acknowledging publicity is generated by the collection of the signatures. Here, they admit a public petition is protected by absolute privilege. For example, from proceedings for defamation, okay? Earlier on I said that, you know, they don't want false evidence. They won't accept petitions for impeachments or reflecting on members, only if it's false, only if it's fake. If you've got a case and if you have got a valid accusation, right, then obviously it might be, it's not going to, you know, it's not going to reflect good on the members. But if it's true, then you're protected from it causing any damage because it's a true claim. Courts are protected because, you know, when courts publish listings of criminals, even though they haven't been convicted yet, when they're defending themselves, they get published, right? You know, and they might clear their name, but at that point they're still, it doesn't reflect good on defendants, you know, when they get their names published, you know, otherwise it might be defamatory, you know, but the court is privileged to accuse them while they defend themselves, right? So, and here they're saying that as a part of a general campaign, it can be very useful, petitioning, right? Even though they have several not use it. So, as a part of a general campaign, for what? You're not going to get anything from a campaign unless you're going to do a petition or unless you're supporting a private or public bill. I don't know what the government think people are campaigning for, or who's going to do anything about it, you know. If it isn't the House of Commons, then they usually won't do anything unless you get a lot of signatures anyway, or you get multiple MPs to support it. So they're acknowledging it can be done it can be done with campaigns, right? And it is protected by absolute privilege. Jacob Rees-Mogg supports this in the HC 235 Parliament paper. He says that it has got absolute privilege. So for canvassing, all you can really do is look at the historic record and see what other things other people have done, advertisements in newspapers or pamphlets or leaflets and things like that. And they exist, there are many of them. It's just that they don't put any rules around it, mainly because they're saying that it's absolutely privileged, and they only seem to have put constraints around the private bills to make it a little bit more professional and uniform by having them in specific newspapers for a specific period, giving parties a chance to respond through the publicising of it. And a little bit like elections have to be done for a fair election. But because public petitions is independently brought, and usually by members of the public, it's not heavily regulated. So it is done through and using the law and privilege of Parliament. And that's just how it is. And there's not really much more evidence that I can think to give other than to show, you know, the actual existence of the materials. People publish full books about their petitions. Some had very long petitions that filled the whole book, and they just published it as a book. Because public petitions and private bills were one and the same before they were split into separate procedures, they actually are really the same thing, other than they have a different set of rules and procedure now for private bills. But they are the same thing and done under the same jurisdiction, that's for sure. So I don't really know what else there is to say about it, other than it's definitely exists in law. It exists in law, or did till 1986, and it didn't go away when this act was repealed. This act just took away the restrictions on the consents requirement from the courts. So this is what it is: to solicit, labour and procure the getting of hands or other consents of any persons, right? To redresses to Parliament. So this is part of proceedings. The proceedings were acknowledged in law, in an act of law. The publicising of it, the soliciting of petitions to either Houses of Parliament or the King, is acknowledged in act of law. Right then, so I checked up on the word solicit, because that's in the legislation which covers petitioning processes set in law to either Houses of Parliament for the restrictions imposed on them. But the restrictions were repealed. But it gives us a definition and proves that the process exists, only that it's not regulated anymore by the restrictions, okay? So we look up the word solicit, and this is from the Samuel Johnson Dictionary, because the Samuel Johnson Dictionary is an older dictionary and it is more contemporary with the legislation. The meaning and definitions of the words are more contemporary with their usage when those acts were made, right? So we've got two results in the dictionary: solicitor and to solicit, right? So this is checking up on the word from the 1661 Tumultuous Petitioning Act, right? And ironically, under solicitor, the first meaning is one who petitions for another. So actually, one who petitions on another's behalf is actually specifically related to petitions in the Samuel Johnson's dictionary for solicitor for the first meaning. So this is exactly on topic for the 1661 Tumultuous Petitioning Act, and it means that one who petitions for another or on their behalf. So this is getting people to act for you or with you for petitions. So this is when you're getting people to help you with canvassing or other persons acting under the agency, because they're acting on behalf of the petitioner or the petitioner, okay? One who petitions for another, right? And the second meaning on solicitor, one who does in chancery the business which is done by attorneys in other courts, right? So actually a solicitor is mean acting on your behalf or acting on behalf of other people doesn't actually have to say whether they're professional or not, or whether they're paid or voluntary, just that they are petitioning for another or on their behalf, right? And then for solicit, we've got there's 5 meanings. 1, 2, 3, 4, 5. I don't know if you want to, you probably can't read those there, but I'll read them out to you honestly here, right? To solicit is, I beg your pardon, to importune or entreat. The second is to call to action or to summon, to awaken, to excite. So if you're putting advertisements and notices out informing people of a petition, you're calling them to action, you're summoning them, or you're awakening them or exciting them to the cause. So call to action. You're asking people to come to the cause, or to come sign a petition, or to come support it, possibly even to come and help solicit it. Right? When we're publicising. To implore, to ask. So to solicit means to actually to ask someone. To attempt or try to obtain, and to disturb or to disquiet, that's the last meaning. So this is all about getting people to come to the petition, to get interest in it, to support it, and to get them to act. So this is actually, that word was attributed in legislation to petitioning either Houses of Parliament or the King, right? In legislation, and that was an acknowledged legislative part of it. Not actually just under the law of Parliament, it exists in legislation, in law, but particularly for the restrictions over it, and the restrictions have actually been removed because the 1661 Act was repealed and the restrictions were removed, so no consents were required anymore to do this. So this actually, it is actually what the proceedings are, the part of it outside of Parliament, were acknowledged in law of the 1661 Tumultuous Petitioning Act.